Welcome back, everyone. Again, my name is John Riley. I'm an Assistant General Counsel at the Copyright Office, and I'd like to welcome you back to day 3 of our Section 1201 rulemaking hearings. Before we begin Class 6A, I'd just like, again, to go over a few logistical items. Should be familiar to many of you. The colleagues and I will pose specific questions, and we will call on participants to respond. Please use the raised hand feature on Zoom to indicate that you'd like to speak. But if that's not working for you, feel free to raise your hand live. Again, we're going to ask that you please try to focus your responses to the particular question asked, and we ask that you keep your comments relatively brief. In addition, today's event is being live streamed, and it's being recorded and transcribed by a court reporter. The video and transcript will be posted on the Copyright Office website, and so we would ask that everyone please try to speak clearly and to mute your audio when you're not speaking to assist with the recording and transcription. And of course, if you lower your hand after you're done talking, that would be great too. Later this afternoon, we're going to be holding an audience participation session. Anyone can sign up to participate in that session using the link that's going to be posted in the chat. We will ask that remarks be limited in that session to about 3 minutes for public participation, which can be on any of the classes. Before we begin, I would like to invite first my Copyright Office colleagues to reintroduce themselves.
Thanks, John. My name is Heather Walters, and I'm a Ringer Fellow here at the Copyright Office.
And I'm Brandy Carl. I'm an Assistant General Counsel.
And now my colleague from NTIA.
Good afternoon. I'm Diana Moreno Hyde. I'm an attorney advisor at NTIA.
Would like to give participants an opportunity to introduce themselves, but I think there is maybe only one new participant. Why don't we go with you? Unless other folks want to reintroduce themselves, we could probably skip that other part of the proceeding.
I'm guessing that's me.
Yes.
Okay. Hi, everyone. I'm Casfina Radin. I am the founder of Small Data Industries. I'm an art conservator in private practice, which I've been doing for 7 years. Prior to that, I was a conservator at the Museum of Modern Art. And prior to that, Rhizome, same place as my colleague Dragon, who you heard from previously. And the reason that I'm here is because in the work that I do as a conservator of art, who specializes in art that uses technology, access is essentially inextricable from preservation. So my clients who are institutions, art collectors, artists themselves, they often hire me to devise means of access and display, because if it's not possible to display, you can't preserve it. Anyway.
Thank you. We're just going to keep the introductions to a very brief part, but we'll give you plenty of time to say your piece. We're going to start with a question from my colleague, so I'm going to turn it over to Heather Walters.
Thank you, John. This question is for the opponents. Do any class opponents have any comments or analysis regarding SPN and LCA's proposal to replace the term private study with teaching in the exemption? Mr. Rothstein?
Yes, I'll first note that was not in the original proposed exemption. As I view it, it was only in the reply, and fairly surprisingly only pointed out in a footnote. At first, frankly, I thought it was just a change, and I saw even this morning it was in a footnote. So I think actually it's too late. There was absolutely no response. But turning to the substance of it, teaching is clearly an expansion. The exemption was patterned after Section 108 of the Copyright Act. It no longer is with teaching, because that necessarily means a proliferation of copies. And again, there's as in the prior proceeding, there's a lot of talk about emulation, but the exemption says distribution. And in fact, it turns libraries, the library model, into the copy shop model. So I think the expansion, A, is too late, and B, overly broad.
Nick Albert?
Thank you. Yeah, so I'm happy to address this. And I want to note that the teaching language was actually in the original proposal in 2021. That was before the Copyright Office, and the in the exemption that was approved in 2021, without, as far as I can tell, significant commentary on why the exemption should not apply to teaching, the language was replaced with the language from 108 that included private study. And so our intention here was to sort of align the exemption with what, I think many folks thought we were already discussing. Indeed, in our initial comments, you can actually see that we cite multiple teaching examples, including the one on page 3 involving AutoCAD, and the examples from John Impolito, which I believe is on page 9. So, even if the language is not, the language change is newer on the reply, the idea that this exemption covers teaching is certainly not new to the reply. Additionally, on this sort of point about, okay, it's too late, I think the Copyright Office regularly modifies these exemptions up until, and in the recommendation. And our intention here, teaching is clearly a non-infringing use under section 107. It's exactly the kind of use that these works need to be put to, and there's a significant need and adverse effect. And so, I want to just reassure the Copyright Office that is why it's in there, is because of that specific need in terms of what the on the ground needs for this for these uses are.
Thank you. Moving to Mr. England.
So just briefly, teaching clearly does have to be viewed as an expansion relative to private use, and whether it is a fair use, so it depends on context, as is always the case in the fair use determination. The example that I was thinking about while preparing for this hearing was, what about a preserved word processor program? Is this exemption something that would allow providing access to a class to use a preserved word processor program and an emulator for purposes of writing papers for class? I don't know. But I think once you include teaching, you need to think through those kinds of scenarios.
And Mr. Taylor?
Yes, thank you. I think that the discussion of teaching is very relevant to our initial opposition to this, is that if this is a non-infringing activity, I mean, teaching demonstrates that they're seeking to do more with this exemption than they're allowed to do in regular brick and mortar situations. I mean, teachers regularly have to put a single book on reserve for a classroom, and people have to individually go and get the reserved copy. And so I just think it's an extraordinary stretch of our understanding of fair use or non-infringing to somehow make possible for this exemption what we can't regularly do in brick and mortar libraries.
Nick Albert?
I'm happy to let Mr. Band speak.
Of course, Mr. Band.
Right. Well, we're happy to talk about the scope of teaching uses if you want. There's no question that you can make all kinds of classroom uses, and I mean, the reserve situation you described. I mean, certainly that there are sometimes physical reserve, but you also can make multiple copies, not just one copy. And so that certainly that was true when I was a student, and it's certainly true now that the multiple copies are available, and then even far more for classroom uses, and that's routine. And again, what we're talking about, remember, this is all in the context of preserved works. And even if we were dealing with the situation that Mr. England was talking about, if it's access to a preserved a word processing program, sure, look, we can construct any kind of ridiculous scenario we want, but do you really think that anyone is going to be trying to avoid licensing a word processing program in 2024? I mean, we all have word processing programs on our computers and our phones. I mean, this is kind of the far-fetched scenarios that we're talking about here about it's not realistic. What people are want to use this exemption for preservation, and then making access to those preservation copies for research purposes, for learning purposes. It's not going to harm the market, and everyone here knows that.
Mr. Rothstein?
Yes, just responses. Yes, there might be multiple copies, and back in the day, even in reserve. But there's if there are 5 multiple copies, only 5 users can take advantage of them at a time with books on reserve, and that is the model. And that model with teaching has been abandoned essentially. I think there can be harm to the market. One of the examples that the proponents use is Final Draft 7. If you look on eBay, actually, you can buy Final Draft 7, and there are comments saying it's not useless, but the people who wanted to buy it apparently tried to use it in order to write screenplays. And if you do that, you're not buying Final Draft 13, which is harm to the market. It's harm to a derivative work. So yes, there can be market harm because these older versions of software often do have, if they could be circumvented, have utility for the purpose for which they were initially created.
Mix Albert?
Yeah, so there's a lot here to respond to, so I'll try to do it in a somewhat structured way. I also want to point out that to the extent that the opponents are arguing that the inclusion of teaching was a surprise, at least as far as I can tell, the DVD CSS comments on page 6 specifically contemplate discussing prohibiting copy of works for future lessons. So are talking very specifically about the rule of spontaneity, which I believe only really makes sense in a teaching context. So I think that if that seems to point to the idea that actually the sort of idea that teaching was such a shock in this exemption may not be driven through, at least in those reply comments. Of course, that doesn't necessarily reflect on other opponents. Obviously multiple copies for classroom use is included in section 107. I won't insult this room by sort of repeating what's in the statute. I also think it's worth noting that none of the opponents here actually represent the rights holders of these word processing companies, right? The Business Software Association has not opposed this exemption. They have not sort of shown up and suggested that there will be any market harm. And they are the folks who produce the software in question here, unless I'm unaware of the ESA, DVDCCA, AACS, RAA or MPA getting into new business models. On the Final Draft 7 point, my understanding is that Final Draft 7 is no longer available from the primary purchaser or from the company in which was originally making it. That's why we use it as an example. I think that in some ways turn us back a little bit to the conversation about sort of the benefits and barriers of emulation, which is to say that the experience of sort of using these kinds of tools with remote access provided by preservation institutions is useful for folks who are sort of seeking to understand a historical experience or access particular software dependent materials that rely on an older version. It is not a particular competition for the existing versions of the work, which is, I believe, why there are no rights holders that represent those organizations here to oppose this exemption. I'll stop there. I'm sure there's plenty of other stuff that we can talk about as we continue.
So I do want to follow up with you regarding something that was brought up previously about acquiring software from the marketplace. And Mix Albert, you stated, or SPN and LCA stated that some academic institutions and organizations won't procure software from eBay or other secondary markets. Could you explain why?
I think it was a mystery to the person who told us why that was true. I suspect if I was to speculate, I suspect part of it has to do with provenance. And that's actually, I think, one of the really important things that matters to preservation institutions, right? Which is that you want to make sure that the version of the software you're running is actually, and my colleague, Mixfino Radin can speak to this, like the version that was sort of released by the company, that you understand the version numbers, etc. Right. And so I think that when you're getting software on the secondary market, that even it can be difficult to fully understand exactly where it's from, whether any modifications were made, etc. But Mr. Band may also know more about that.
I do want to pass it to Mr. Rothstein, and then we can go to Mr. Band.
Sure. The unwillingness of institutions to buy from a particular market isn't a TPM issue. It's an economic issue that relates to whatever business decision the institution is making. So, in fact, it shows that there are alternatives to circumvention because there are avenues of purchase.
And Mr. Rothstein, you had also just mentioned that the expansion can be a harm to the market. So I just wanted to ask, given the current exemption, has there been any harm to the copyright owners?
Well, under the current exemption, I don't know of any, but certainly with this expansion, it's conceivable. And that is why we did not oppose the renewal of the current exemption.
Thank you. Back to you, Heather.
Thank you, Mr. Band.
Right. When you're buying software off of eBay, you also don't know, in addition to the provenance questions, you don't know. I mean, if it's used, then you have licensing issues. You don't know if it's you might be violating license terms by buying it, and so there's a whole thicket of legal issues that come along with software because of the licensing problems that accompany it.
Mr. Taylor.
Yes, I just want to respond very quickly that it's not exactly clear to me that DVDs did not at some period indeed host some software programs. It was a brief period in time, but to say that DVDs, that we don't have any interest in this is fairly overstated.
Ms. Fino-Radin. I believe you're on mute.
So sorry. I just wanted to speak on this issue of secondary market procurement. Coming from a different context, not working within an institution, I am more than free to buy things on eBay, and I regularly do in my practice. However, in my experience, I think, sure, we're going to cherry pick some examples. Yes, there's obsolete software you can find on eBay, and sometimes it's even shrink wrapped. However, in my practice, I found there are many, many cases where you can't. And truly the only copy available anywhere in the universe is a cracked copy that's commonly found in piracy communities. And in a lot of cases, those can be sometimes more trusted because they've been vetted by a community of connoisseurs rather than some thing you found on eBay or can't find on eBay.
Thank you. I will pass it over to my colleague, John.
I think we had one more follow-up from Mr. Ayers.
Thank you. Just very quickly, just to build on what Mr. Taylor had said, actually in the context of DVDs and in Blu-ray discs, there actually are a number of software players that incorporate content protection technologies for playing back these discs on PC platforms, on computer platforms. And I would also note that just historically, to the extent there have been attacks on the CSS and AACS technologies that result in distribution of illegally obtained keys, those have generally come from software players. So software in the DVD and Blu-ray context is actually very important, and so we do have a very definite interest in this, even if we are not directly publishing ourselves the playback software.
I'd like to just briefly give proponents a little bit more chance to talk about where software is being acquired generally. Would anyone like to take that? Ms. Albert.
I'm happy to start, and then I'm, happy to turn it over to my colleagues if they have sort of more to say. So I think that, I think you heard it in our saw in our initial comments that I think one of the folks we talked to literally said we just, we try to acquire software whenever we see it because we don't know if we're going to need it. So generally speaking, I think that, part of that is that literally it can come in as part of a collection, like an archival collection, right? So if someone donates their papers, maybe they have a copy of the software with it. Folks might also purchase it sort of directly, although that can be complicated for licensing reasons, as Mr. Bam was mentioning. Or there may be sort of like others, it may come in with a sort of broader, with a particular other, through other means. I think generally speaking, many of the organizations we talked to, it was not a collection priority, but they understood that they often would need these forms of software in order to access works. And that meant that what that means is that folks may be much better at actually acquiring that software now, but historically, folks were not necessarily acquiring particular versions that might be required to obtain software. And Ms. Fino-Radin may have more to sort of say about the mechanics of that.
I'd go to Ms. Fino-Radin first and then to Mr. Rothstein.
Sure. So my colleague raises an important point. I think we've been spending a lot of time talking about the commercial softwares themselves as almost the thing that we're trying to distribute or provide access to. But I think it's really important to remember in most cases in this context, those are supporting materials that really aren't the point. However, they are critical for the authentic display and access to the artifact. One particular use case from my practice in the past when I was at Rhizome, I spent years trying to recover the remnants of an electronic bulletin board that was called The Thing. It was the first online community created by and for visual artists in the North America. We unfortunately found the board was gone, but eventually we found that a user had saved screen dumps of the board over the years in the form of text files. They at first appeared to be corrupt, but through some forensics, we eventually found they were WordPerfect files. And in my preservation work, I looked high and low, again, happy to buy things on eBay. The particular version of WordPerfect that we needed simply didn't exist. The only copy, I eventually found something online, a cracked copy, and it was incredibly obscure. And had we not used that, and had we not used emulation to access these files with this cracked copy, and therefore recover the the raw text of this board, it would have been lost and gone forever. And it resulted in the board being shown in an exhibition at the New Museum years ago, and that would have been impossible otherwise.
Thank you, Mr. Rothstein.
Yeah, I mean, the focus of the change is the elimination of the one user at a time language. And in the examples that we've heard of in the comments, it's, I believe, Mad Men, and it's the papers of Vladimir Nabokov. I don't get the sense, and there's no evidence that more than one person at a time is clamoring. There's not a line down the block to get access to those. The objectives can be met leaving in the one user at a time language. This just doesn't require elimination of that language. Certainly no evidence of that.
I'm going to turn to the two folks that have their hands up right now, but I did want to ask another question to the extent you want to answer this as a part of your response. Proponents stated that the current exception could be interpreted in two ways. The first interpretation is that the preservation institutions can allow a piece of software to be accessed by as many individuals as there are circumvented copies owned. The second interpretation is that the preservation institutions, excuse me, can only loan out one piece of circumvented software at a time, regardless of how many circumvented copies that they own. If feel free to respond to anything that's been said thus far, but I'm interested in how preservation institutions are currently understanding the one user at a time component of the current exemption. Ms. Howard.
Yeah, so let me tackle, I think, Mr. Rothstein's comment first about the sort of like, oh, there aren't folks lining up around the block to access Vladimir Nabokov's papers, because I think it represents a fundamental misunderstanding of sort of like what the issue is here, right? And I want to make sure that we clarify it. So it's not just that one user at a time would be able to access Vladimir Nabokov's papers. It's one user at a time would be able to access all archival materials that require that particular form of software. So in that way, it's actually much more like saying one user at a time could access a book, right? It is an entire genre of things, not just that one specific collection access. In addition, because of how software works, right? There are multiple pieces of software potentially with their own TPMs that are required to access a work, right? So you both have the like, okay, what kind of software do you need to access that particular archival collection? But in our comments, we provide the example of Windows XP activation, which turns out to be something that a number of software preservationists feel very strongly about in a way that maybe not be sort of legible to outside folks, because of the fact that so much historical software relies on operating systems, and the sort of fact that it's becoming more and more difficult to activate those operating systems without necessarily circumventing a TPM means that there is sort of advancing harm, right, to the ability to emulate those works. With regards to, I'm so sorry, Mr. Riley, I totally forgot your question. Would you mind just very briefly repeating it?
Right. Actually, I hope that it leads into what we're talking about here.
Oh, sorry. It was about the two different interpretations.
Yeah, and we'd like to know how the current exemption is working and how people are viewing the provisions as they are right now.
Yeah, so I think that folks have been, my understanding is that folks are taking a more conservative tact, right? In terms of sort of not necessarily tracking how many pieces of software they have, but sort of thinking about it as, okay, we may be able to loan out one copy at a time. But I think that more generally, I think that in the case of sort of things like operating systems or other kinds of support, like supporting software, the risk, even if they were saying like, okay, we can loan one user per individual copy, if you're running an sort of emulation as a service system that is of the type that is sort of, I think, considered the future of software preservation, right? That may still not be sufficient for the types of supporting software necessary for folks to access archival collections. And then Mixpino Radin will have much more to say on the specifics of how that works than I do.
Right, Mixpino Radin.
Sure. So I'm so glad that Mr. Rothstein brought up this question about multiple user access. I have an example from my time working at the Museum of Modern Art that I think illustrates this perfectly. So there was a co-acquisition between MoMA and the San Francisco Museum of Modern Art of the papers of Susan Kerr, the graphic designer that designed all of the original user interface for Macintosh, Windows 3.1, pretty much every way that we use computers today was shaped by her. And the archive consisted of some notebooks and about 150 floppy disks. And a colleague from SF-MoMA and I, both in the conservation departments, needed, it was our job to provide the curators with a way to understand and see and curate these materials. So what we did is we created an emulation environment, and essentially we rolled our own emulation as a service, so to speak. And this was necessary for the curators at MoMA and SF-MoMA on different sides of the country to be able to be looking at the same thing. Just simply giving them both copies of the floppy disks and different operating systems that were legal and doing their work independently just wasn't possible in this case. So imposing a one copy and single user restriction is simply unnatural in this case. And I think it's important to remember that the software in question here wasn't the object of study. It was the archival materials from use and care, but that supporting material, that supporting software is inextricable. You can't see it without it.
So let me ask a maybe clarifying question, but please correct me if this is not right. If a preservation institution has a preserved program that is just dependent on a preserved operating system, is it typical for someone who wants to access, as an example, an AutoCAD file, an older AutoCAD file, would the preservation institution typically have one copy of Windows 98, one copy of the older version of AutoCAD, and then for each of those two preserved pieces of software, one person can access a dependent piece of material, or what is actually happening right now? McSaller?
Yeah, so I think that what is actually happening right now is I think folks are kludging together various solutions that mostly are not necessary. That I think that the institutions generally take conservative positions. So I think yes, right. To that extent, if an institution is very is really trying to follow the rules, has one copy of each, that is one copy that it might be available to users. I think right now, sort of the number of institutions that have copies of the software is so small that frankly, this isn't happening a ton because no one actually can access any of this stuff, right? And that the models that the preservation space is moving to, emulation as a service models, require multiple copies of the underlying software in order to be useful and provided to users. So I think, when we hear from institutions about the positions they're taking, they tend to be incredibly conservative, right? And that the risk associated with it and the lack of clarity around what is allowed means that right now institutions are often just not necessarily making things available because they worry about those kinds of risks. I hope that answers your question.
Thank you. Radden.
Yeah, so in terms of how things are happening now, I absolutely agree with my colleague in the sense that there's a sort of mix of certainly chilling effects that current law is having on preservation and curation practice. Institutions absolutely erring on the side of being conservative, even if what they're doing might not, be breaking the law, because they just don't want to have a target on their back. Simultaneously, there's the opposite happening, of course. There are institutions that are just going about doing their work of preservation and curation, hoping that it falls within the context of fair use. And I think it's important to remember that there are many contexts where, you were asking about one copy of an operating system for one artifact that's preserved. That absolutely is not done at least not within art museums. The art museum might be going to the trouble of making sure that they have at least one copy of everything that needs to support it. But let's say going back to MoMA, not to pick on them, but the Department of Architecture and Design I think is a great example because a curator there, Paola Antonelli, would frequently show an exhibition of 25 video games or pieces of software or things, and let's say half of that all depends on the same operating system or some specific program. Now you're in a situation where legally it sounds like, I'm no big city lawyer, but it sounds like you would need to be having unique copies, legal copies for each of those. And if we multiply that, think about the fact that there are museums all over the world showing these things. We very quickly get into a situation where when we're talking about obsolete software, there's just likely not enough copies still in existence to make that happen.
Just to be clear, I was asking not whether the preservation institution had several copies of, for example, an operating system, but would they need one for one if they wanted to make a piece of software, whether it's AutoCAD or Acrobat. If people wanted one copy of each and using those at the same time, it sounds like they would need two copies of the relevant operating system as well, with those operating systems acting as a pinch point. Okay, thank you. Mr. Rothstein.
Yes, just briefly on the point that institutions are taking conservative views of exemption. One would think that if there's a perceived ambiguity, the proposal would be addressed to that perceived ambiguity and not radically change the exemption. We don't see, however, any kind of discussion of ambiguities that could take care of what some feel are unduly conservative approaches. We see something far different.
Ms. Howard?
I'll just be very brief. Yeah, we tailored the proposed exemption to the needs of the relevant preservation community, which is both to resolve the ambiguity, but moreover to not have the number of copies that someone may have saved of an operating system from 1998 be the thing that determines how many people can ever access an archive or run particular other pieces of software. I think the idea that we should only address the ambiguities rather than actually responding to the adverse effects of the anti-circumvention provision does not seems to me to be a little bit strange.
Mr. Taylor?
Yes, I would just add to that, but it's not the 1201 that's creating the adverse effect. It's copyright law itself. And while you suggested that 107 allows you to make multiple copies, it does not, and there are not libraries out there making multiple copies for the purposes of filling their special reserve requirements. So, I mean, you're again just asking for something that is not consistent with good copyright policy.
Albert?
Yeah, so I would point Mr. Taylor at Corellium from the 11th Circuit, which is directly factually on point about making multiple copies of software for the purpose of sort of like research other secondary uses, and found those uses to be fair. Moreover, Corellium was a commercial use of software that was still on the market. So to that extent, the works covered by the exemption are even more likely to be fair use. So to the extent that opponents are arguing that we are not, we're the ones with the problem with copyright law, I would suggest, consulting that case, as well as, cases like Google v. Oracle. I could keep going, but it's in the comments, so I'll just stop there.
I believe that opponents had in their comments tried to distinguish some of those cases. So I'm going to go to Mr. England next, but we'll come back to you, Mr. Band.
Just on the specific subject of the Corellium case, a couple of points. First, and maybe most important, the office should recognize that that's an unpublished decision by the 11th Circuit, and under 11th Circuit Rule 36.2, that means it is not a binding precedent. And so, of course, the office is free to evaluate whether it thinks it's persuasive, particularly in light of the subsequent Warhol decision. But there's less there than has been portrayed by the proponents here. In terms of the merits, I think first of all, it certainly doesn't purport to tell the office how it should analyze proposed exemptions. It, like all fair use decisions in the courts, is addressing a particular use case, in that case, some virtualization software. But as the Warhol decision teaches, that involved a specific use. And so it analyzed that use. And here, the exemption that's been proposed potentially encompasses a wide range of uses. And the office needs to take those uses into account. It can't simply ignore some of them, which is how the proponents would like to use the Corellium decision. So I think it is not particularly relevant.
Go to Mr. Taylor, then Mr. Band, then Ms. Albert, excuse me.
I could have clearly missed it, but I don't think anywhere in the decision it addresses the fact of whether or not multiple users of the software is indeed a non-infringing use. I think they looked specifically at what the technology was doing and reached its conclusion on non-infringing use on that point. And I think it's a very far stretch to say that that's what that the case actually stands for, what you say it does.
And I'm going to jump in and suggest that, to the extent that people have made these arguments in their written comments, we don't need to go over them again. It's relatively beneficial to hear some factual discussion of what's happening and what proponents want to happen. So with that context, Mr. Van.
Yeah, then if we're not going to be arguing about, you know, the legal issues and just rehash that, then I'll lower my hand and let Ms. Alpert, you know, address this.
I was just suggesting, in the interest of time, if there are points that have been made in written comments, we don't need to repeat them here. But if there's new points, including legal arguments, please feel free.
Yeah, I just so yeah, we addressed the idea that Corellium doesn't talk about multiple users in footnote 13 of our reply. On the question of how it being an unpublished case and Warhol, so that same 11th Circuit rule that you read, Mr. England, of course, says that these cases can be cited as persuasive authority. I don't think anyone argues that circuit case law is binding on the Copyright Office, and so to the extent that a factually analogous circumstance is obviously directly relevant to the question of what uses are fair, and that the Copyright Office has regularly engaged with circuit case law in the past, Corellium is therefore useful. And I believe that in fact the 11th Circuit was asked to reconsider Corellium in light of Warhol and did not. And that Warhol doesn't fundamentally, I think, change the analysis in Corellium. And I can go into more depth as to why if the Copyright Office is curious, but I'll respect the focus on factualness and stop there.
I'm going to move on to a question about emulation again. So there have been comments made addressing emulation as a service. Emulation does not appear in the current exemption text. It may be helpful to understand a little bit more about what is happening with respect to emulation in this context, including whether operating systems are being emulated, computer-dependent digital materials, the AutoCAD software and those files. How is emulating working here? And to what extent are users who may be remote, is there any sort of storage of data, files, copyrighted works? How is that working for the end user as well? Ms. Fino-Radin.
Sure. So I think just an important distinction when we're talking about emulation, in 99.9% of cases, the operating system is not the thing that's being emulated. It's actually the hardware. And this really gets to the fundamental challenge in preservation work when we're talking about digital artifacts. Everything at the end of the day, so we have, let's say, a particular file format that an artist worked in. And in order to see that, we have to use a particular piece of software. And in order to use that, we have to use a particular operating system. And in order to use that, we have to be running on specific hardware, because at the end of the day, all software was compiled to run on specific hardware. And you very quickly run up against the challenge that it is just completely impossible, just due to physics and entropy, for the world to have enough obsolete hardware to preserve cultural heritage, period. Eventually, it will all be gone, and emulation truly is the only practical way to continue to provide access to software that was compiled for certain hardware. So the emulator is essentially a software representation of a particular chipset, of a particular hardware design. And it's that allows us to, run this whole complicated stack of dependencies and supporting materials that, extend from the operating system, further up till eventually you get to the thing that you're actually trying to study and observe and curate and write books about.
Ms. Albert?
Yeah, just to expand on Ms. Fino-Radin's comments, right? So part of the reason emulation has been the direction in which most preservation institutions have moved is because it does allow people to access works in ways that allow much more limitations than sort of running the version locally. So, you can say that in most cases, emulation as a service context, yeah, folks are not running the software on their machine, as I think Mr. Espenschied said in the last hearing. It's sort of like being on a Zoom with the software in terms of your level of access. As to one note of caution there, we don't write that into the rule because there are circumstances under which certain kinds of software materials running certain kinds of software in a context in which you're doing scholarship would require actually like some amount of sort of local data access. For example, if you're sort of uploading materials to run through the program, or if it needs to access your camera, that kind of thing. So, the lack of specificity there, which I know is something that folks have had objections to, has to do with actually just like the mechanics of the fact that different settings require different tools. In terms of this, I think in terms of the question that you posed, Mr. Riley, about the sort of ability to kind of like lock down these systems, emulated environments allow for sort of much more limited access. In addition, they also allow basically preservation institutions to sort of set up the correct way to view materials. So if you go on the Emulation as a Service infrastructure website, you can see that there's a whole bunch of different sort of like default modes through which you can use to access materials. And folks can kind of say, hey, actually this particular archive, this particular piece of art, this particular work is best accessed with these particular settings and this particular operating system, this version. And that is a really important thing to be able to do in order to provide end users access in a way that actually allows for them not to have to care about the kinds of very specific things that Ms. Fino-Radin is an expert in.
Just to follow up on that, if let's say I'm going to take advantage of the current exemption and I have an old AutoCAD file on my computer, how does it work to view that, to access that file? There's some references to the emulation service being in the cloud. Am I uploading the file to the cloud? Just a little bit more detail on that would be helpful, I think.
Yeah, I believe you are uploading the file to the cloud, but I would like to just confirm with some of the Emulation as a Service folks to make sure I'm not speaking out of turn. So I'm happy to follow up with the Copyright Office with a more specific answer if that's okay.
Mr. Band.
Right. I just wanted to again bring us back to what we're trying to do here. So using the examples that have been talked about before, you have the emulator. On top of that, you have, let's say, the operating system, and maybe circumvention needed to be done to get the operating system to work with the emulator. And then on top of that, you have the application. But all that's already been done, right? That's all that's already okay for purposes, for the existing exemption, any circumvention that was done to allow that to operate. But the problem is that you might have a large number of works that need to use that stack. And right now, that stack can only be used by one user at a time. And what we're saying is because that stack might be servicing a large number of works, it's conceivable, and it's not only conceivable, it happens that there could be more than one user at a time that wants to access part of this corpus of, this Apple developers files, and there might be hundreds or thousands of her files, but only one stack that allows access to them. And so that's why you might need more than one person to have access at a time.
Mr. Taylor?
Well, we disagree with Mr. Ban on whether or not this exemption needs to be modified. I do want to make clear it has not been our position that we have gotten into parsing how they engage in preservation. And we would assume in good faith that, the way they engage in preservation really is not at issue for us today.
Going to turn the next question over to my colleague, Ms. Walters. Oh, yeah, if you want to take question number 5.
Thank you, John. Would the current exemption cover a circumstance where computer-dependent digital materials can be operated by a computer program that is currently in the marketplace even if an older version is not in the marketplace. For example, if current AutoCAD software is backward compatible, should the exemption cover discontinued versions of AutoCAD? Let's start with Ms. Fino-Radin.
It's a really, really fantastic question. So I think the best articulation that I've ever seen of this is a report written by a colleague of mine, Ewan Cochrane, who I believe is still at Yale. At the time he wrote this paper, he was at the National Archives of New Zealand, and it was called the Rendering Matters Report. And he showed that, even with materials as, seemingly trivial from a visual perspective as government documents, that just because something opens in contemporary software doesn't mean it's being rendered correctly. And he showed incredible examples, like example after example, evidence, clear visual evidence that there was significant information loss just because something can open in Word today, but it was written like in WordPerfect or some other obsolete word processing software. There can be things like charts, graphs, tables, very important data that is simply either rendered illegible or rendered incorrectly, even though it does open, let's say, in a contemporary version. So I would say yes, absolutely.
Ms. Albert?
Yeah, I think just to echo Ms. Fino-Radin, like, we don't understand the exemption to sort of cover currently available on the market software, even if you can open older software dependent materials with it, in part because that is a use case that is unrealistic, right? Folks who are attempting to access older materials are going to try and use the actual software that they were created with for the reasons Ms. Fino-Radin flags. Additionally, I wanted to just come back to Mr. Riley's question because I wanted to just confirm that, yeah, so if you had an individual AutoCAD file that you wanted to use the emulation environment, you would upload it, but often that process is actually done in partnership with a software curator or through a negotiation, because generally what folks are doing is accessing materials that are already owned by or controlled by a library, right? So you're accessing someone's papers, and you're using the emulation environment. It's much rarer for folks to upload their own materials.
Mr. England?
So I think this last couple of minutes of discussion is important, and it was a great question because it really highlights that this is an exemption that exposes a lot of valuable copyrighted software to circumvention. And Mr. Band didn't like the example I gave early in this panel about word processing software, but I think we just heard from Ms. Albert that yes, even though there are current versions of word processing software in the market, this exemption would permit a library to provide access online to last year's version of that word processing software. And that may or may not be helpful for particular research projects, but when one then talks about eliminating the per user single user requirement, I think you're setting up a scenario where a library could post an emulated version of a word processor on a website, and as long as it didn't have notice that it was being used for non-research purposes, it would be there for people to use. And that may not be the intent. I think probably not the intent of the organizations that are represented here, but that's what the regulation says. And I got to take the regulation at face value and assume that anything it permits is something that someone might want to do.
Ms. Albert?
Yeah, I guess I'm confused by Mr. England's comment. Yes, you can, the fact that there is an existing word version of Word on the market still doesn't mean you can't circumvent Word 2003 for purposes of making it possible to preserve it and provide access. That's the whole point of the exemption. Indeed, that's the exemption that currently exists, and we heard opponents say earlier that there's no evidence of market harm from that. Like as I think said in our initial comments, there is no evidence that folks turn to older versions of the software when they could have the option of newer versions. And other than for the exact purposes that Ms. Fino-Radin was flagging, in terms of because you need it in order to view the works in which it was originally the works in the context in which they were originally produced. I do not think providing the fact that folks can now provide access to more users there's no evidence that this is going to change the lack of market harm.
Mr. Band?
Yeah, and I'll just go back very quickly to the point, 2 points that Ms. Alpert made earlier. One that, again, the software makers are not here. They don't care. And this also relates to the bigger point that from the previous hearing where Mr. Ms. Albert pointed out that Mr. England said, there is no condition under which the opponents would sort of agree to the exemption. Look, what's going on here is that you have a few associations that are ideologically opposed to any exemption whatsoever, and whenever any new exemption whatsoever is proposed, they oppose it. That's fine. They have that First Amendment right, but that's, and then they were able to come up with, they hire very good lawyers, and, Mr. England and I in particular have been tangling with each other in these proceedings and in other proceedings for, I don't know, at least 30 years. And that's all well and good, but the Copyright Office needs to take all of these concerns about all these terrible things that might happen with a grain of salt. I mean, none of these concerns have ever come to pass. There is a performative quality to this, all of these rulemakings. I'll stop with that.
I'll let the record reflect that Mr. England is a very good lawyer. Mr. Taylor, next.
Yes, well, I again disagree with Mr. Van over our intentions here. And I think I can point out many times where we've been very cooperative with respect to exemptions and the needs of certain communities. And just in this conversation, I just said that the way you engage in preservation was not going to be what we were concerned about. So that being said, I do want to direct the office's attention that somewhere along the line, we did have this discussion about obsoleteness, and somewhere that has disappeared from the current exemption, but there's a plenty record and precedent on what the register has considered relevant with respect to your question on, and specifically, I would just direct you to the discussions on obsoleteness.
Mr. England?
Mr. Ben and I have been friends for more than 30 years, I think. So I feel a little old, but I can't let his suggestion that the associations are without an interest here go without a response. The major copyright owner associations care greatly about effective copyright protection for all kinds of works, and also protection for the TPMs that enable commercialization of those works. And that depends upon proceedings like this one being carried out in accordance with the rigorous standards that the office has always applied in these settings. So even though I'm not here as a representative of business software, we definitely care that the office analyze any proposal rigorously in accordance with the standards that have developed across the last 8 triennial proceedings.
Let me ask a follow-up. There is already an exemption to the extent that this expansion is asking to remove, the single user time requirement. It would have unlimited potentially users using the exemption. Is that a concern if the amount of users were bounded to a number like 3? Would that be something that would address your concerns to a degree? Is that what you would call movement as you've made in the past, or is it just a non-starter?
But as Mr. Van pointed out, these aren't my members' works, so I can't speak to what details the copyright owners of particular software might be comfortable with or might not be. But I think you put your finger on the point that when you're talking one user, you're a very controlled experience that really replicates the library special collections experience. And once you take that away, you are potentially in a world of infinite access. And if there were my works or my clients' works at stake, I would find that very scary.
Mr. Ayers?
Thank you. Yeah, just to also respond that, as I noted before, AACSLA and DVD-CCA, both, while not direct publishers of software themselves, have a very direct interest in the protection of software that in which our content protection technologies are incorporated, which then also impacts the potential unauthorized exploitation of the copyrighted audiovisual works that were designed to protect. And I would also clarify that making sure that that this proceeding sticks to the standards that have been set out is hardly performative and is actually a very valuable and good faith participation in the process. So Mr. Band, I would disagree with you on those characterizations. And I would note that while we haven't specifically said that in this proceeding, we've and we continually we continue to object to the expansion at all under the conditions that have been discussed so far. But as we've noted in many other proceedings and for other classes, to the extent the Copyright Office is considering a recommendation that includes some desire to accommodate the request for the expansion or an exemption, guardrails are better than no guardrails. And so I share the concern that Mr. England expressed about infinite use. And recognize the point, Mr. Riley, that you raise about, well, what if that use is more than one, but less than infinity? Certainly, there's probably something reasonable that can be reached, although we've not discussed and have no record provided in this proceeding as to what that number might be and whether it's a good idea or not, and whether it addresses the concerns or not. So it's, but anyway, I'll leave it at that.
Seller?
Yeah, so wow, a lot there. But I'll try to just sort of maybe wrap up a little bit because I know we're close to time. So I hear AACS and the DVD folks saying that they represent folks who have TPMs on software. They provide no examples of those in their comments. They have provided no examples here. Despite the fact that there is no market harm from the existing exemption, there is no discussion of meaningful market harm in the comments with regard to this class. You know, there is no examples. There are no, not even like Mr. England's, you know, emulating Microsoft Word instead of and students using that are not present there. And you know, I know the Copyright Office in the past has actually been pretty hard on folks for the sort of idea that one can just speculate about sort of the consequences. And so I would just turn a critical eye towards opponents' approach there. And so I just want to kind of come back to kind of what we're here, what the proponents have the burden to prove, which is that the use is non-infringing. Under Corellium, the fact that it's multiple users it doesn't even still means it's fair, even in the context of a commercial use. That there's no evidence of market harm here from the existing exemption or even from providing more copies. And that fundamentally I think we have pointed out in our comments why the single user restriction has significant adverse effects. You know, saying 3 copies or 5 copies does not deal with the reality of how many works are dependent upon, as I believe Mr. Riley, you put it, the pinch point of relatively small numbers of sort of underlying software. Like, this is the nature of how software preservation works. And the reason we're back here is because, you know, when in 2021, we didn't include a single user restriction, you know, and it was something that was added, I think, because the Copyright Office wanted to include additional restrictions to sort of provide safeguards. It really has significantly harmed and held back the efforts to provide the kind of emulation as a service access that is the future of providing access to preserved software. You know, we're back with this exemption because the folks that SPN works with has said that this is really harming their ability to do the work. And I really encourage the Copyright Office to take that into account as it crafts, you know, as it approaches the exemption request.
Thank you. In the interest of time, if people who have more comments could keep them brief. I'm going to go to Mr. Taylor, please.
Yes, I'll make this very quick. The burden is on the proponents to show that it is non-infringing. And as far as we have been concerned so far, the proposed activity is indeed non-infringing, and it doesn't require much more discussion than that once we have demonstrated that. And yeah, I will leave it at that. Oh, but one more thing is we don't get a reply. So this is structured in a way that we don't get a full back and forth. Thank you.
You're talking about the written comment stage.
Yes, Mr. Riley. I mean, so
just clarifying for the record. Yes, Mr. Harris.
Just a quick response to the point that Mix Albert raised, and I think a valid clarification to make, and to the extent that I was misunderstood or did not state it clearly, I apologize. DVD CCA and AACSLA do not represent directly software publishers, and we make no claim to represent software publishers in this proceeding or in any proceeding. However, these software publishers that do make available DVD and Blu-ray playback software have signed license agreements with AACS and DVD CCA for the respective content protection technologies that are included. There's been an agreement to maintain the security of the secrets that are involved in maintaining the encryption and protecting the content that is played with those software players. So we do still definitely have a very direct interest in how those software applications may be treated, even if we're not representing the publishers directly.
And I'm just checking if Ms. Hyde has a last question for us.
Sure. I'm just trying to get some kind of a clarification from the written record and what's been said at this hearing. Is there a retro market for the auto software other than the video games that were mentioned in the record? Or is it the continued utility of the types of software like Mr. Rothstein had mentioned that make it a continued viable market? And that's mostly for the opponents. Mr. Rothstein.
Well, the examples we have found, it's the continued utility of the software, and certainly with the final cut, there seems to be a continued utility, and certainly perhaps with word processing. But I will say that a lot of the proponents' examples deal with the need for old software's utility.
Thank you. So seeing no more hands raised, I'll yield it back to my colleagues.
Thank you. We're going to wrap this session up. I want to thank everyone very much for this helpful discussion. The office is going to reconvene at 2:30 for proposed class 7. Thank you again.